Thank you, Dan, and I want to thank the Cato Institute for inviting me here today to speak at this event. It's a real joy to be back with my friends at Cato, where I published a number of things on this issue back in the day, including a paper that's out front on the Internet tax solution, tax competition, not tax collusion, that I co-authored with my colleague Veronique Derouget, who also works with me now at the Mercatus Center. It's also nice to be back here with Dan. 20 years ago this month, I came to Washington and took a job at the Heritage Foundation, working just around the corner from Dan in the office, and he was a great mentor to me, a mentor in the sense of teaching me things like how to go out and drink mass quantities of beer at lunch and come back and still pretend to get work done, and a variety of other things that we can't talk about in public. But anyway, it's great to be here. I want to step back in this debate. This is a very complicated issue. I've been covering this now for the better part of 15 years, going back to my time at Heritage, where I published numerous papers on it, testified in front of the Internet Tax Commission on this in 1998 or 9, wrote a book for Heritage on federalism and interstate commerce and technological issues that related a lot to this issue. This is complicated because really you have to go back to the very founding of our republic to understand why this issue is so contentious. You have to remember that America's Constitution is not really our first Constitution. We had something called the Articles of Confederation before that, as most of you know, but it did not last very long. It only lasted about, I think, 14 years. And we promptly abandoned it after we realized that the downside of that was that sort of untrammeled states' rights approach was not going to ultimately help us breed the kind of union we were looking for, specifically the sort of commercial union we were looking for. And the real stroke of genius in our Constitution, well, there were many forms of genius in our Constitution in terms of human rights and so on and so forth, but the fact of the matter is, what's often forgotten is that our Constitution created the world's first free trade compact. And we have a free trade agreement among the states, thanks to the Constitution, that sets out certain guidelines about how commerce among the states will work. And this was really, again, why we abandoned the Articles, because Articles of Confederation did not have provisions that help deal with the interstate trade disputes or tax disputes that might arise. And so the Constitution handled this in various clauses: Article 1, Section 8, Clause 3, the Commerce Clause; Article 8, Article 1, Section 10, the Compacts Clause. A variety of other provisions in the Constitution dealt with this. So why is this important? Well, we have to flash forward a long time, come all the way up to about the 1930s, when the states decided they needed to start devising alternative revenue mechanisms during the Depression era because of the fact that other types of revenue mechanisms were failing. So along came the sales tax. And at first it was pretty small, and it was fairly small for a long time. Up around 1950, it was still only averaging about 1.2%. But it grew and grew and grew. Today it's somewhere a combined rate of over 6 or maybe more than that now, I'm not sure. But the fact of the matter is that what made it so complicated was that once the interstate market really started robustly developing in America, we started having real tensions with our sales tax, because our sales tax was taxing goods at point of sale, and most transactions were taking place at a counter in a certain store, department store, whatever else. It's fairly easy to administer this tax system. So when interstate commerce came along and so-called remote sellers, interstate vendors of commerce, came about, there were some real complications posed for our sales tax system. And many state and local governments said, well, we need to be able to trace and tax all that activity in the name of tax fairness. This really first became a huge problem with regards to things like catalog and mail order sales, and it was forced, the courts were forced to deal with this ultimately. And along came a series of cases that dealt with so-called nexus, or the physical present standard by which a state would know when they could actually tax or not tax. And the court laid out some guidelines for this because Congress refused to essentially act in this front. So a body of so-called dormant Commerce Clause jurisprudence started to develop, and today we're still stuck with it. We had cases starting in the late 60s going all the way through 92 and some other decisions in between that dealt with this, but basically the law of the land is nothing that really Congress has passed or that the states are dealing with. It's really what the courts have handed down in a handful of decisions. And so we have a situation today that is really quite a mess, because Congress has, so far at least, decided not to act, remained fairly silent on this. The states have moved aggressively to try to find a way to equalize tax treatment in the name of tax fairness, trying to impose the same sorts of destination-based taxes on interstate vendors that they impose on Main Street bricks and mortars vendors. And you've been left with this real trouble about how we're going to do this in a fair and constitutional fashion. Now, why is it that the states can't do this? Well, the states can't do this because, of course, these companies who essentially administer the sales tax system on their behalf are obviously not in their states, or else they would have to collect. But when they do not have the sufficient nexus or physical presence to allow the states to do this, the states have sought to try to impose it anyway in a variety of ways, but the courts have again held the line on that. So what the states really want is some sort of a blessing from Congress to essentially go ahead and find a way to impose these taxes in a constitutionally permissible fashion. They want to also do this in conjunction as part of a multi-state compact or accord. Now, these are not unprecedented. We've had other multi-state compacts dealing with things ranging from agriculture policy to steel policy and a number of other things, water conservation. But the really tricky thing here is, again, going back to our founding period, you're dealing with something that is unambiguously interstate commerce in nature. So goods that move over mail order or catalog or now the internet obviously have a clear interstate component, and many of these companies are interstate vendors in character. The states cannot do this, at least in my personal estimation, they cannot do this without the blessing of Congress. And so we've had legislation introduced now for many years that would essentially grant that blessing to the states. The most recent bill introduced by Senator Durbin would do this by, I think it's the Main Street Fairness Act, and that would basically give the states and localities the power to do this as part of this compact. So, is this a good idea? Well, for many of the reasons that Dan Mitchell already talked about, I think there's some real serious concerns that some of us in the free market community have with this sort of an approach. My concern begins, as the title of my paper with Veronique for Cato implied, that the first principle in this debate that people are always fighting about is tax fairness. But tax competition is every bit as important as tax fairness. And also, when it comes to tax fairness, there's many other ways to skin that cat. I mean, let's be clear. In fact, many years ago, I remember working closely with a lot of folks in the retail community trying to get them to understand that, look, we'll all come to bat for you in state capitals and help you fight burdensome taxes that you pay that others do not. Because let's be clear, there is a bit of an unfairness here in the sense that mainstream vendors are currently paying some significant tax burdens, and maybe some other players are not. But that does not justify by any means necessary approach to getting this job done or achieving fairness, especially when other constitutional principles are at stake or tax competition is a value that we care about. And therefore, I think the better approach would be for retailers to understand that ultimately what you're doing when you endorse a multi-state tax accord for the purposes of getting taxes imposed on the new kid in town, the internet, is you're probably shooting yourself in the foot in the long term. Because, of course, you yourself may be a vendor of interstate commerce in other ways, or you may be setting up a bit of a Frankenstein monster that you think you can control or at least keep in check, when in reality there might be better ways to go about dealing with this problem. That hasn't, of course, won the day. I think many of my friends in the retail community believe that it's still more sensible or maybe just practical to go ahead and find a way to impose taxes on the internet by any means necessary, including through some sort of a so-called simplified sales tax project. Which brings me to the simplified sales tax project. Now, I don't usually bring props to events, but I wanted to make clear what simplification looked like. So there's 200 pages of it, and it's really not quite as simple as one would hope. In the name of simplification, we've had this battle going on for some time now about how to define all these things, and there's a huge appendix to this that sometimes makes for great comedic reading when I read through things about all the different ways people can define clothing and clothing equipment, or essential clothing, or protective equipment and fur clothing, sports and recreational equipment. There's a lovely section in here on dietary supplements that goes on for many pages, and my personal favorite on disaster preparedness fastening supplies, with a great section on bungee cords, rope, and duct tape that goes on for many pages. So, I guess we're getting more simplified. I don't know. Maybe we are, maybe we're not. But why are we doing this? The states have spent years doing this. And in theory, I guess I could believe that if it was truly simplified, that there would be some advantages to that. Of course, really quick, let me make one point here. We talk a lot about federalism in this debate and states' rights. But the states do get a lot of rights under this sort of a system if they're given them by Congress. But what's important is that we have to understand federalism also goes right down to the local level in this country, and the localities kind of get screwed. In fact, in the Durbin bill, it very specifically says that anybody who's a part of this, that a member state may choose its individual tax base, provided, however, that all local jurisdictions in that member state with respects to which the taxes imposed or collected shall have a common tax base identical to the state tax base of that member state. So apparently states' rights only goes so far. It goes as far as the state borders, and then the localities are kind of screwed. You're coming along whether you like it or not. So in a world where we want to have vigorous interstate tax competition, we also have to understand that's local tax competition, and localities should have their say, shouldn't they? But clearly they won't under this kind of an approach. But anyway, back to the point about simplification. For many of the reasons Dan pointed out, simplification is not all it's cracked up to be, and it really could end up running counter to the goal of tax competition. Because what the states are essentially doing here is creating what I have labeled in my papers for Cato and for Mercatus. They're setting up essentially a de facto tax cartel. Now remember, going back to the period of the founding of the sales tax was never a federal tax. Many of us are happy about that fact. But the fact of the matter is that because it's not a federal sales tax, the states are allowed to essentially set their own rules, and they have because there hasn't been a problem with them doing so, hasn't conflicted too violently, again, with the interstate marketplace. Here it most certainly would with this sort of a plan. And when it does, Congress has certainly within its rights to actually set some ground rules for it, and the Durbin Bill would do some of that. But at the end of the day, it would grant a great deal of power to the state and local governments, but specifically to state governments, through this multi-state tax compact, to set these rules of the road for the interstate marketplace. And I really do fear that that sort of a model really has dangerous long-term implications for taxpayers and for interstate commerce in general. Because you're establishing a mechanism of local control for something that is, again, unambiguously interstate in nature. So what's the alternative? Well, Dan's already talked about the one that I favor the most. It's really just a change in the sourcing rule. Let's be clear. We've talked about this as a destination-based tax system, but when you think about it, as Dan already pointed out, when you go into a store today and you buy something and you pay a tax, it's really an origin-based system. Nobody asks you, where are you taking that pack of gum you just bought and that we taxed you for? Where are you going to chew that pack of gum? That's not done. Where are you going to read that book? So at the end of the day, our current sales tax system is really, in a sense, an origin-based system. And that's all we're saying it should be for interstate sales. The way you would accomplish this is you would have a very simple fix. You don't need 200 pages to do this. You don't need 40-page bills. You need a two-page bill. A two-page bill that will essentially say what the sourcing rule is for the taxation of interstate sales or remote commerce in this context. Now, what would that rule be? And this is a little bit tricky, but you could basically say it's a principal place of business rule. It's not an incorporation rule. You can't just say, well, I'm incorporated in Delaware, and Delaware has no tax, so thank you very much. No. It has to be something to do with your actual substantial physical presence, where your primary headquarters is at in this world, where most of your employees are at. Whether or not you would have other states have sufficient principal place of business rules that they also would qualify to tax is a good debate. But the bottom line is that this would create a very pro-competitive tax system, so much so that states who hear this say, well, this is crazy. This is a race to the bottom. Everybody will be competing vigorously on taxes, and that will really hurt our ability to collect them. You know, to which I respond, well, I'm sorry, I'm not going to shed many crocodile tears over that one. I think that's a good thing. This is, as computer engineers would say, this is a feature, not a bug. And so what we want to do, I think, with federal policy is to be careful that, A, we don't cede too much authority to the states as they go about trying to find a way to get congressional blessing to tax interstate sales. But if we do cede any authority to them, we cede the authority that is consistent with our Constitution and consistent with sound principles of tax competition, which is to say probably an origin-based rule. Again, it's not the only system, but I think it's the most practical one. Many years ago, people forget that Senator Hollings introduced, when he was still in the Senate, a bill that would have imposed a federal sales tax on the Internet. I think it was 5%, and then somehow found a way to remit it back through some sort of a revenue-sharing formula. Well, that would be a real mess, and we'd start a whole new federal tax base and system to try to collect taxes for this purpose. I hope we don't go down that path, but it's certainly another way to handle it. And, of course, we probably should mention, I'm surprised Dan didn't, that the states could try to get their profligate spending problems under control and try to constrain their spending so that we don't need to collect as many taxes. But I know that's a losing proposition these days as well. So let me just be clear and end on this note that, in the name of fairness, we have to be careful about how we approach tax policy in this country because there are many other values at stake. For some of us, tax competition is the higher and more important of these values. And, we should be careful, I think, here in Washington at the congressional level to understand that while Washington has taken away many powers from the states unjustly and usurped many powers it should not have, the one unambiguous power under our Constitution that our founders got exactly right was the power to oversee commerce to ensure free and fair trade among the states. Let's keep it that way. Thank you.